Okay, so that's working over there. So worst comes to worst, I got that. So
Trying to cut out that crown molding without cutting out my damn head. Let me see if I can go lower in the chair first. Oh shit. That was not what I wanted to do. We'll make it work.
okay. So what I've learned to do is to read off a Word document on my computer and then check it when I've asked the questions. That way I don't lose track of where I am. When I'm trying to hold these things, I always lose track. What question did I just ask you? Yeah, so
See,
anyhow, that
looking
worked.
at my notes here, I've got notes on everything through number 13. And then I've also got notes on number 27. And some of them, if you want to, we can do off the cuff, but I'm trying to put more time in the. So I follow Alex Hermosi, and he says, I learned a long time ago that an ounce of work on the script on the head end pays dividends and a pound of work on post production. So I'm
Yeah,
trying to give y'all better content to work with, which in theory should lead to better results.
right, right, right.
Not get your
Yeah,
foot in
yeah,
my face, but
yeah. There's no doubt about that. So, okay, well, why don't we get going?
all right.
What type of cases do criminal defense lawyers handle?
A good criminal defense attorney handles all kinds of cases, whether it is a misdemeanor or it is a felony, whether it is a state case or a federal case. In Mississippi, for example, you may get a felony charge out of Rankin County. Well, that's a state case. It's going to be held in our circuit court. The flip side is you could technically have a charge out of Rankin County that also violated a federal crime. Think about somebody doing wire fraud or something like that using banks. Well, in that case, you're also going to be in federal court in the Southern District of Mississippi. And a criminal defense attorney could handle either one of those. And again, we handle misdemeanors and felonies. So if you've got some speeding ticket or a traffic ticket of some sort, all the way up to a murder case, which would be a felony, a criminal defense attorney would handle that. A good criminal defense attorney would handle that. That's not to say that criminal defense attorneys find niches within criminal defense. For example, I do a lot of DUI work, but is that exclusively what I do? No, but I do a lot of it. And there's some attorneys out there that I bump into. All they handle is speeding tickets. That's how they make their living. That's what they do. And there are some attorneys out there that all they handle is felonies. Think about public defenders who do it full time. A lot of those guys are handling felony work all day, every day, and then you get into further breakdown of do you handle only federal work or do you handle only state work? And some attorneys do that. I do everything with a focus on DUI defense.
When should I hire a criminal defense lawyer?
You should hire a criminal defense lawyer as soon as possible. If you have bonded out of jail, go call that lawyer immediately. You want to hire the best lawyer that you can afford as quickly as possible. If you're still in jail, then you need to have a family member reach out to an attorney as quickly as possible. An attorney can file a petition for writ of habeas corpus to try getting you a bond. If there is no bond, they can file a motion for a reduction of bond if the amount is so high. I think $1 million. Well, on $1 million bond, you're going to end up putting at least 10% down, which is $100,000, and you'll have a turnkey fee, which is usually around $50 per charge or something along those lines. So in that case, it's worth getting an attorney to go and get your bond reduced. Now, if you've got a $10,000 bond, it's probably not worth it for you to go get a bond, hire an attorney for a bond reduction. But as soon as you possibly can get to a lawyer, get to a lawyer and don't talk about it to anybody else. Clam up. I need to talk to my lawyer before I talk to my mama. That would be the approach I would take on that 100%.
What should I look for in hiring a criminal defense lawyer?
1 second. In a DUI defense or criminal defense? I'm sorry.
Criminal defense.
What you need to look for in a what you need to look for in a criminal defense lawyer is somebody that'll shoot you straight. You need somebody that will tell you the good, the bad, and the ugly about your case because every case has those points to it. And it's against human nature to want to give bad news to somebody or talk about something that's negative, that's got an impact on not only their life, but their kids' lives or significant others' life, the parents' lives. You need an attorney that can bring all that to you and talk to you and have a real conversation and that isn't scared to do it. So you need a human being that kind of goes against human nature and will tell you everything. As humans, we generally don't want to tell everything. I have clients that try hiding stuff from me, and you need somebody that is going to lay it out there no matter what. You need somebody that you are going to trust, that you are comfortable talking to. If you're not comfortable with that person, it doesn't matter that I'm a great lawyer. If you're not comfortable with me for whatever reason, I'm not the lawyer for you. The flip side of that is the same thing with clients. If I'm not comfortable with this client, if I don't think this client is giving me everything, and I think they're hiding the ball on something, then I may not take that case. So you need to be comfortable with that lawyer, and that's why a consultation is so important when you have that, because questions go both ways. That lawyer is interviewing you just like you're interviewing that lawyer. So you need somebody that you are comfortable with. You need somebody that is going to just shoot it straight to you, because if you got a strong point and the attorney needs to be able to say you need to take this to trial. If you've got a weak case, the attorney needs to be able to talk to you about what your realistic exposure is over here. Are you looking at years in the penitentiary? Are you looking at a license suspension? What are you looking at? And you need an attorney that can do an assessment and say, this is a case that is worth taking to trial, or this is a case that you really ought to let me go talk to the district attorney or the prosecutor and see what we can work out. Steve, I'm about to put mine on do not disturb. Bailey is just blowing me up. Okay.
Was that beep on your end?
Yeah, that's me.
Okay. Okay.
Bailey and Mom are the two people that have unfettered and unfiltered access to me, which means her texts come through no matter what.
Yeah, I understand. Okay. What should I do if I'm being investigated for a crime?
If you're being investigated for a crime, the first thing you do is shut up. I don't want you talking to any investigators or any detectives. They're called investigators and detectives. Let them go investigate, let them go detect. You don't have to give them a damn thing, so don't do it. And then again, that's against human nature. Humans, we want to explain our side. We want everybody to understand that we're being fair. Nope. You talk to one of those investigators or detective, you've locked yourself into that story is your best case scenario. Those facts are there forevermore. If you don't talk to them, they don't have that. You can't misquote silence. Okay. Now they can say, well, he didn't talk to me. And that's where you affirmatively assert your Fifth Amendment right. Because once you say, I exercise my Fifth Amendment right to remain silent, that stops it. They don't get to say, well, he didn't cooperate or anything. You have no damn duty to cooperate. Okay. So go talk to a lawyer. If you think you are being investigated, first, shut up. Second, exercise your Fifth Amendment right to remain silent. So that kind of is a little counterintuitive, but do it and go talk to a lawyer. Do not talk to the investigators about the case. You're not going to get more information out of them than they're going to get out of you 99% of the time. They're trained in this. You're not. So shut up after you exercise your Fifth Amendment right and go find you a lawyer. That is exactly what I would do if I was being investigated. If either one of my boys were being investigated, that is the advice I would give them. If my mama was being investigated, that is the advice I would give you, is to exercise your Fifth Amendment right and shut up. That doesn't mean shut up for a little while and talk later. No, be quiet. Let them arrest you, let them do what they're going to do, and go find you a lawyer as soon as you can after that, and a good lawyer at that.
Should I talk to the okay, this keep in mind these will be separate videos. So should I talk to the police before consulting a lawyer?
Absolutely not. Here is the extent of your conversation with a police officer. I exercise my Fifth Amendment right to remain silent. That is all you need to say to a police officer under any circumstances. Do not talk to the police. Shut up. It is the best advice I can give. Exercise your Fifth Amendment right to remain silent. Now, the question is do I talk to the police before a lawyer? Don't talk to the police with a lawyer. I'm not saying under extraordinary circumstances that there's no case that I would ever say, let's go talk to the police. Uh, but it would be a truly, truly extraordinary circumstance and probably part of a plea deal or something like that, where an individual would be talking to the police uh, with me present. But no, don't talk to the police before you have a lawyer, and you're probably not going to talk to the police after you have a lawyer. You see on the shows where the police sit down with the lawyer and the client in the room. Have you noticed they always get sideways? And have you noticed the client always says something that they shouldn't say? That's why you don't have your client talk to the police, is you don't want to set that up. That is tantamount to malpractice, in my opinion, short of extraordinary circumstances where everybody has sat down, talked about the pros, talked about the cons, and everyone is aware of the risk on the table, and they go forward with something under those extraordinary circumstances. Short of that, don't talk to the police. Don't talk to them without a lawyer, and you probably shouldn't be talking to them with a lawyer unless you've worked something out, unless you've gone through and had a real conversation where everything is on the table and everybody's on board.
What happens during an initial consultation with a criminal defense attorney?
Well, bet you got that picked up nice and loud. Sorry. What you can expect for a consultation, what you can expect from a consultation with a criminal defense attorney is, first off, there's going to be a general intake before a consultation ever happens. We need to get some basic information from you so we can figure out what's going on in your case. Next is going to be the preparation stage. This is where you're going to send over any documents that you have so that we can review them. This is where we're going to pull statutes. We're going to go pull your case on Mississippi Electronic Courts or PACER and see what's going on your file before we hop on the call. And from there, once we've got the prep down, I'm going to have an actual call with you usually. Probably 90% of my consultations are done over the phone. I have folks come in. I love it when people come in because I like to get to meet my clients or potential clients in person. But when you got somebody that's 2 states away, that's not always feasible. Or you got somebody that's on the road making a living. I get that. It's just the way the world turns. Thank goodness we have the technology that allows us to circumvent that to a degree. Now, when we're in there and talking about it, it can take anywhere from 10 minutes to a couple of hours. I don't set times on my consultations. When it comes to a consultation, so long as we're not going in circles, I'm glad to keep answering questions and keep laying out what your options are. Somebody calls me on a simple seatbelt ticket. It's pretty straightforward. I tell them what the statute is, tell them what the penalty is. These are your options. You know, you go down there, it's going to be procedural for the most part. If the police officer shows up and says that you didn't have your seatbelt on, well, it's a straightforward cut and dry scenario. But I've also sat down with people that have murdered people, and that is not a 10-minute conversation. I'm here to tell you that is something that's probably going to take hours by the time you go through all the facts. You analyze what they're looking at, whether it's going to be manslaughter, second degree murder, first degree murder. Are they looking at a capital murder situation? And you need to walk through everything. A DUI consultation, for example, normally takes somewhere between 20 and 40 minutes. And uh, a lot of that is because I know the statute so well off the top of my head at this point that I'm not digging anything up. There's not anything that's really going to surprise me for the most part that I see on them. And I can lay it out there for my clients. And there's not a lot that they're going to give me at that stage. They're usually going to have a citation for me to look at. There's not going to be any formal filings that I can go pull or see anything along those lines. So every once in a while, I have a client that has gotten the police report or some other documents, and that's really exciting and fun to me. A felony consultation, you think a malicious mischief or a straightforward simple drug case. Obviously, you get into the trafficking and things like that. You're starting to get up into an hour or two because you got to figure out what exactly is going on here. Um, on the simple drug cases, again, you get to lay out all the various options. They take a little bit longer because there's drug court, and then there's also pretrial diversion that are options, and then there's the penalties. And a lot of times they got some misdemeanors that are tagging along with that, and you need to be able to lay it all out there. And I tell people the maximum penalties, and sometimes I tell them, don't be scared by what I'm about to tell you, but I think it would be me not doing my due diligence to tell you what your true exposure is. For example, speeding ticket in the state of Mississippi carries up to 10 days in jail. Well, what I'm going to tell you is I've never seen anybody go to jail who wasn't doing 100 miles an hour in a dozen years of practicing law. So unless you really just pissed a bunch of people off somewhere along the way, you're probably not going to jail on a speeding ticket, but I can't guarantee you that. And I think it's my duty to tell you what your maximum exposure is. And I always couch it in those exact same terms because I don't want you to get to jail, get not to jail, get to court, and they say, well, he carries up to 10 days in jail. And you look at me and go, what in the hell? You never told me this. So you've got to be prepared to lay out what the minimum penalty is, what the maximum penalty is, and what your experience in that jurisdiction says that this is likely is going to happen if you want to take a plea or you're found guilty at trial. And obviously, if you're found not guilty at trial, you walk out of there a free person. That's something else that needs to be covered. So it is a consultation with us is not a let me pick up the call and just have this real quick while I drive back from lunch. No, there's some prep work that's going into it on the backside of things. By the time I hop on the phone, I've probably got 15 minutes all the way to an hour sometimes in a case, just making sure that I can have an intelligent conversation because we don't do free consultations. And because we don't do free consultations, we believe that we've got to provide a lot more value than everybody else. And I want my clients to understand everything that's going on. My DUI clients, they get a DUI roadmap so they can see exactly what they're looking at from beginning to end. And you can't do that on every case necessarily. Lay out a roadmap that's a flow chart, but that lets you know that we go pretty deep into our consultations and that you're not just getting us doing it off the cuff and saying, hey, here's our quick fee, hire us. No, if you think there's somebody out there that can do a better job or um, you don't feel comfortable with me, whatever reason, and same thing, if I don't feel comfortable with you, we've actually talked about this in a different Q&A where you've got to be comfortable with the attorney that you're looking at hiring. That's my stuff buzzing right now. It should stop.
What kind of evidence can my lawyer use in my defense?
So most of the evidence that a criminal defense lawyer is going to use defending your case is actually going to come from the state. I'm not saying all of it, and I'm not saying every time most of the evidence comes from the state, but most of the time, most of the evidence comes from the government. Now, what we're looking at as far as the evidence that would be used would be video evidence. So think body cams, dash cams. Sometimes these ring doorbell cameras pop up in evidence these days. Uh, Traffic cameras pop up, license plate readers are all part of that. And then we also have audio evidence because sometimes police officers may not have a body cam on, but they may be wearing a microphone that is recording, or maybe the microphone is attached to the dash cam. Mississippi Highway Patrols is pretty common for them to have dash cam, but not to have a body cam. But they've got a microphone that's picking up everything. And you get to listen to all the audio evidence that may be there. And there may have been bugs, there may have been wiretaps, all kind of stuff could be obtained in surveillance that'll be part of the discovery file that the state has to hand over once properly requested. And we've all seen the Lincoln Lawyer where he's riding down the road listening to the tapes. And sometimes that literally happens. You're riding down the road trying to listen to all this audio. You may have 40 hours worth of video or audio that you got to go through. And let me tell you, that's a lot of popcorn. So you've got to go through all that. Then you've got the documents, the reports, statements, photographs, records. you start getting off into financial records or phone records. My gosh, you can lose yourself in there. Medical records, you go to the ER for a simple cold, it's 115 pages worth of documents that are generated off of that by the time they've got the discharge papers, admit papers, and all the doctors that have signed off on everything, plus all the meds they've given you. So think of an aggravated DUI, somebody gets hurt. Well, those medical records, you better be prepared to go review them. And photographs and other documents, statements are a big one. And reading some folks' handwritten statements can be a real booger sometimes. Some folks still write with crayon, I think, as opposed to just typing it out. And you got to try figuring out what they're saying because their grammar may not be the best either. Uh, so there's a lot of evidence that can come into play, and then we can go and get some evidence. A lot of times I've had clients show up and say, hey, I've got dash cam, Joey, and great, we'll take it, let me look at that. And I've got some clients that say, hey, here are the photos, here's this, here's Facebook messages, whatever. And while we may not be able to get that particular thing in, that may be enough for me to go get a subpoena issued to go get those records that would come in. And it's not often that we have that. And sometimes we have call logs, and call logs cut both ways. They can be really beneficial. They can be really bad. I've had cases before where somebody sent me a screenshot of their call logs, and I started calling all the people on those phone numbers that I saw. About the third one down, I realized this ain't going to be a damn good thing. So you've got to be able to go through all that, and all of that may be used. It may not be used. It may be admissible. It may not be admissible. And those are all hurdles that still have to be overcome. But the first thing is you got to filter through it all the evidence that is out there before you determine what can be used in your defense or what you want to try keeping out from the state's perspective for use in your against you in the prosecution.
What's the difference between a misdemeanor and a felony?
Well, the big difference is a misdemeanor can't carry any more than a year in prison and or in jail. In a Let me start over. The big difference is a misdemeanor carries up to a year in jail, and a felony carries more than a year in prison. So the statutes, the way they're written in Mississippi, if it says up to 3 years in prison, well, that's a felony, any which way you cut the pie. If it says sentenced to the penitentiary, well, that's going to be a felony by definition. Anything that is a year or less, think of a DUI, child endangerment, it says up to a year in jail, then you're looking at a misdemeanor. Once you cross the threshold, anything that's over a year, according to our case law, says that that is a felony. So if it carries up to 3 years in prison, you're in the felony world. Carries a year or less in jail, then you're looking at a misdemeanor. If it says county jail, misdemeanor. If it says penitentiary, felony.
Oh, wrong spot there. Sorry about that. Okay. What are my rights if I've been arrested?
Well, your biggest right is the right to remain silent. I know if you watch any of my videos, you will hear me say that repeatedly, and I mean that. If you would just exercise the Fifth Amendment right to remain silent when you're arrested, you will eliminate probably 75% of the problems of your case. Because what you say in that interview or in the patrol car riding down the road, all that gets used against you later. That's the worst case. It's used against you. You've admitted to something, you can't back out of it. Your worst case is, your best case is at that point then becomes, well, this is just what we're framed up in now. We can't get around this. This is the story that they have. This is what we're married to at this point. Because if you say something else, well, did you lie then or are you lying now? It creates a real problem. So if you would just shut up, that is the best thing that you can do. I can't stress that enough because folks think they are going to talk themselves out of a problem, and that's human nature. We all try doing that to some degree. You need to fight that damn urge because that's the absolute worst thing you can do. And I'm telling you, I've never seen one of my criminal defense clients talk themselves out of the problem. They've always talked themselves into the penalty of it. That's the problem. So exercise the Fifth Amendment. And after that, go get an attorney, and not just any attorney, get the best attorney you can afford. You want somebody that's going to focus on your case. You don't want to just be another rat on the wheel situation. You want somebody that's going to take the time, put the custom work in, and handle your case the way it ought to be handled. So shut up and get a lawyer. That's what I would tell anybody that their key rights are when they've been arrested. You have that First Amendment right to free speech. Don't use it here. Be quiet. You have the Second Amendment right to bear arms. Nope. Keep the guns away. You don't want to be dead. It doesn't matter what you really don't have any legal problems. If you're dead, you got your family's got other problems. So stick with the Fifth Amendment. Stick with your right to an attorney. You've got the Fourth Amendment right against seizures. Don't consent. If you've exercised your Fifth Amendment right out the gate, you said, I exercise my Fifth Amendment right to remain silent. Wada bing, wada bam. You can't consent to a search at that point. So if they say, can I look in this? No, hell no. Exercise your Fifth Amendment right to remain silent. Go on. And they say, well, can I look at this? I've exercised my Fifth Amendment right to remain silent. And what that means is they need to go get a warrant, or they got to have probable cause. If they've got probable cause, they didn't need your consent. That just made it super easy for them in case you ever try arguing that there's a Fourth Amendment violation, because you consented at that point. Let them go argue probable cause, preserve things for your lawyer to deal with on the backside. You don't realize it, but you're building the case against you at this stage. Don't do it. Exercise the Fifth Amendment right to remain silent. Go get a lawyer. Don't let them search your stuff.
Can a lawyer get my charges dropped?
Sorry, fight this thing. Yes, a lawyer can get your charges dropped, but it's not going to be in the manner that you think. Everybody has this idea, especially in Mississippi, that we're all just a good old boy system, and I'm going to call Junebug and he's going to get everything tossed, and we're not going to have to go to court or anything. Or I'm going to call Matlock, and Matlock is going to say, no, we won't prosecute him. Junebug's the officer. That's not how it works at all. What happens is we follow procedures. We have the rules of criminal procedure, and we have the rules of evidence. We go and we get the evidence that they're going to use against you. We review it. And if it's a crappy case, I can call most prosecutors up and say, hey, Matlock, this ain't so good. Junebug messed this up over here, I think. And you might want to take a look at it, because when they get on the stand, they're going to have to account for all their foul ups. And it may be best that y'all dismiss or null process, which is effectively the state dismissing the case, and everybody go on about their ways. So that happens in the sense of a dismissal in that manner. But it's not going to be the, hey, buddy, would you mind just dismissing this for me? Wink, wink, nudge, nudge. And if you have strong arguments and they say, nope, we're not going to dismiss. Nope, we're not going to null process this. Okay, well, we're going to we're going to go file motions and argue this and let the judge decide that. And if that's not enough, then we'll go put it in front of a jury and let a jury decide it. Or if it's a misdemeanor trial that doesn't get a jury, then you turn around and put it in front of the judge and let the judge make the decision once and for all. So yes, a lawyer can help get the charges dropped. It's just not going to be in the manner that you think.
What is a plea deal?
A plea deal is the criminal equivalent of a settlement in a car wreck case. This is where everybody is going back and forth over what the terms are going to be that everybody can live with. And the thing is, and here's the real difference, you're not talking money. You're talking years in prison or jail time a lot of times. Not every time, but especially when you get off into your felony cases, that's exactly what you're negotiating, is how many years somebody is going to go to prison. So you've got to take into account everything that is going on. You've got to look at the risk to your client going forward. You got to look at any aces you may have up your sleeve. Maybe you got a key witness that you think is going to make the case, and you tell your client, well, maybe we ought not take this deal. We should move forward with a trial. And the flip side of it is you can point out all the downsides and the exposure they have. If, for example, somebody's looking at life in prison because they're a habitual offender. They had a violent case out there before, and it's a violent habitual offender, which means you're going to die in Parchman if you're found guilty in Mississippi. Well, maybe negotiating for 5, 10, 15 years is something that's on the table, depending on the facts of your case. But again, that's the major difference in a car wreck and a criminal case. You're not talking money, you're talking somebody's life. Now, there's also a caveat whenever you're doing plea deals and plea bargaining. Just because you agree to something and the state agrees to something doesn't mean it goes through. Unlike a civil case, criminal judges got to approve it. You know, I can go settle a car wreck case tomorrow for whatever amount, and the judge really doesn't have a say so in it unless there's a minor involved. But on a criminal case, just because the state works out a deal, the judge can say, "No, I'm not approving that. That's not fair to the government, in their opinion, or to the constituency." So you've also got that added wrench in there that can fall into the gears. So plea bargaining in a criminal matter is really high stakes, really nuanced, and it's got more that can go wrong with it than you realize. Because even once you work out the plea bargain at the court level, whether it's the federal court or the state court, then you go over to the Mississippi Department of Corrections or the Bureau of Prisons if you're in federal system, and they've got their own ways of handling things. The feds, they've got their guidelines, so they're way more streamlined in a sense. And Mississippi Department of Corrections, on the other hand, well, I mean, it's up to them whether or not to grant probation or parole, whether you qualify for it. And it takes it out of the court's hands. So when you're working out deals, you need to understand all the moving pieces, not just on the front side, but also on the back side.
And then this will be a separate video, but of course, but what happens if I refuse a plea deal?
If the case isn't dismissed and you turn down a plea deal, then you go to trial. And there's really only two reasons someone turns down a plea deal. First, principle. They take the position, I am not guilty, I am innocent, I did not commit this crime, I am not taking a deal, which is reasonable, rational, and it's human. So I understand people that do that and make sure that they understand that the risk that they are taking, and we move forward from there because this is their case at all times. The second reason somebody would turn down a plea deal is the deal isn't a fair acknowledgement of the pros and cons of the case. There's a disproportionate risk allocation. You know, if the states want you to go serve 25 years and you're a 50-year-old man and your maximum is life in prison, well, hell, they're not going to take that deal. I'm not going to recommend you take that deal. Your life expectancy for a male is what, 74 across the board in Mississippi? So it's hard to tell somebody to go take that deal. And you do better to go to trial. And that can give you a lot of leverage sometimes to negotiate it down better or something like that. And there's also the chance that you're sitting on some key witness or some testimony out there that you think is really good that the state's just not factoring in to their analysis of what they think a fair deal is. And it could be a critical motion pending before the court. I've had that happen before where we ran past all plea deadlines and everything because we had a good motion that was going to make or break. And we took the position that even if we lose everything, we're still going to appeal on this ground, which interestingly is actually up. It's not my case, but it's actually before the U.S. Supreme Court right now on geofencing. They heard oral argument on it in January, and we're waiting for a ruling later this year. Now, there could also be the issue that we think the government's witnesses are shakier than they perceive them as being. Maybe this person's got a slew of things going on. Maybe they are a jailhouse snitch. You pick the reason. It could all be out there that you say, no, I don't want to take this deal because they're not taking in a reasonable allocation of the risk here. And in those situations, you make the educated decision as a client whether or not you want to move forward. Hopefully, you got a good attorney there that's laying it all out so you can make informed and educated decisions on what you're doing because this is your life at hand. And we want to make sure that you get the best possible opportunity at the best possible outcome.
How long does a criminal case usually take?
You're about to get the classic lawyer answer. It depends. Because you got to break it down. Are we talking a state or a federal case? Are we talking a felony or a misdemeanor? And what I'm going to tell you, between state and federal is almost always quicker. They call it a rocket docket sometimes because it's just that. You may get arrested on. I guess we'll stop here. They're about to run a fire truck through here, it sounds like. Sorry, they got the main drag right beside my window here. Another reason I didn't want to do that call at 2 o'clock or something is because there's a guy that leaves right down there. He's got glass packs on his damn truck.
Oh boy.
He's got to rev it for 30 seconds every time. So I'll just start this one over.
Okay.
You're about to get the classic lawyer answer to this question. It depends. And it depends on whether we're talking state or federal, whether we're talking felony or misdemeanor. All those make a difference. Federal is almost always going to be quicker. It's not unusual to get arrested on a Monday, indicted on a Tuesday, and you can be arraigned shortly thereafter within a week or so. And your trial can be, initial setting can be within a few months. So I would say between 6 months and a year is what you're going to be looking at on most federal cases. Of course, the larger ones, Jackson's got the big case going right now where the mayor's on trial along with, or the former mayor, I should say, and the district attorney, and they've got a councilman on trial. That trial has been pending for, it'd be right at 2 years. I think it's set for June or July. So that's an unusual case, but there's also a bigger investigation. There's going to be more evidence there. That's why you're going to see a longer time on that one, on the federal one. State cases, again, you're still stuck on the depends on where you're located. What's the jurisdiction we're talking about? Madison County just last year actually arrested a man, indicted him, pled him, and sentenced him all in the same week. And it's a really unusual circumstance. They just so happened to have a grand jury sitting when he got arrested for some egregious crime, and they indicted him right then and there. And they turn around and he pled. So it wasn't my case, but it's just interesting to let you know how quick they can move. So Madison, Rankin counties, you're going to be in that, I'd say probably 9 month to 1 year time frame most of the time. It might slip down to the 6 month number on occasion, and once in a while it bleeds over past 1 year. Again, you think of the more complicated cases or bigger profile cases, things along those lines. They may take longer. You get off in Hinds County, good luck getting a trial. You could be 2 or 3 years out there in the wind before anything happens on your case. Now, that's dealing with felonies. On misdemeanors, I would say the average time frame on a misdemeanor is somewhere between 4 and 6 months. Yeah, I've got some that spill over past the 6 month mark. It's not many, but generally 4 to 6 months is what you can expect most misdemeanors to resolve in. And Steve, I got notes on number 27, and that's the last time I got notes on. If you need me to go off the cuff on a couple of them, I can.
Well, hold on here. Let me.
Again, I was trying to provide you better content so that.
No, that's okay. I mean, we can truncate it. No big deal. I just got to put the numbers back on them because I take them off when I'm just putting okay. So which one was it? What is beyond a reasonable doubt? Is that the one?
That's it.
Okay. Go ahead.
Beyond a reasonable doubt is the top of the burden of proof mountain. That's the best way to think about it. You are trying to get to the peak of Mount Everest for beyond a reasonable doubt. And at the very base, you got reasonable suspicion, which means they've got some specific articulable facts that show that you may have done something. That is reasonable suspicion. I'm really watering this down. It can go way deeper, but that's the base level that you're looking at. And right above there, you get off into probable cause. That means they got facts that would lead an ordinary person to believe something happened. And you go above that on this mountain, you get to preponderance of the evidence. So preponderance of the evidence means more likely than not. That's all it means. It's called the featherweight burden. If it's a feather's weight more on this side than this side, preponderance of the evidence. Clear and convincing evidence is the next step up the mountain. And you're getting towards there, but you're still not there. It's a firm belief or conviction in something. Still not there. The very peak of the mountain for burden of proof is beyond a reasonable doubt, and it requires the elimination of every reasonable doubt that you could possibly have out there on a case. And it's important to understand that the state and the defense don't start off on equal footing. The state's got to start way back over there and work their way up that entire mountain. You don't just start at clear and convincing evidence. You've got to start at the bottom and climb that entire mountain. If they don't climb that mountain to beyond a reasonable doubt, then you don't get found guilty. And if you're a juror sitting on a jury, you got to understand the state's got to climb that entire mountain. That is literally what it is. They carry a burden. The burden is climbing that damn mountain and getting to the peak of it. If they don't get to the peak of it, you can't, in good conscience and lawfully, find somebody guilty of a crime.
And then what was the other one?
Let's see. Oh shit, I'm wrapped up here. I can do some more if you need me to, Steve. Those are the ones that I prepped out. I see you got what is an appeal? How does the appeal process work? I can do those pretty simple if you want.
Okay. Okay. So what is an appeal?
An appeal is where you think the judge or the jury got the ruling wrong. And when I say a judge or a jury, it depends, because if it was a misdemeanor, all you ever had was a judge, and he is the finder of fact. He is everything. That's the one that you would be appealing exclusively. And then when you get off into the felonies or you have a jury trial, there could be something that the judge did wrong. There could be something that the prosecutor did wrong. Could be something that the jury didn't consider properly. All those things get filtered in to determine whether or not you have an appeal, on top of all the procedural stuff. They didn't indict you properly. They didn't list an element of a crime properly. All those things can get appealed. And the appeal process can be a little bit convoluted, but on a misdemeanor side of things, think of it as if you had your trial at the municipal or justice court, then you're going to go up to the county or the circuit court for an appeal, and you get what's called a trial de novo from the beginning. And from there, you can appeal up to you always appeal up to the Mississippi Supreme Court beyond that level. And they kick it over almost always to the Court of Appeals. Court of Appeals will hear your case. And if they think that, if you think that they got it wrong, you can always do what's called a petition for writ of certiorari to the Mississippi Supreme Court, and they may deny that certification and kick it back and say, we're living with that opinion. If you are at the felony level, then what you're looking at is you file an appeal from the circuit court directly to the Mississippi Court of Appeal, Supreme Court. The Mississippi Supreme Court is going to send it over to the Court of Appeals. You got to remember the Court of Appeals is there to help out the Supreme Court. Supreme Court only wants to hear things that they haven't heard before, or novel facts, or something that's a new issue in front of them. And they take a certain number or percentage of capital cases that come through there. Well, I think they actually take all the capital cases, but they take a certain percentage just right off the top that they keep. And once you go to the Court of Appeals, after they rule, you go back up to the Supreme Court and see if they'll hear you, and they may or may not hear you. If they do, great. If they don't, well, you're stuck with the Court of Appeals opinion.
How does the appeal process work?
So the appeal process almost always involves a bond. You got to put up the bonds in municipal and justice court. If you want to appeal up, you got to put the appeal and cost bonds up, and you've got to go and file notices of appeal. And it's very similar in the circuit court. When you have a felony, you're appealing from a jury trial, you have to file judgment notwithstanding verdict, and go through the procedural steps that preserve your case. And then you turn around and you can file a notice of appeal up to the Mississippi Supreme Court. The Mississippi Supreme Court may or may not hear your case. If they decide they don't want to hear your case, they send it over to the Court of Appeals. If the Mississippi Court of Appeals rules on your case, you don't like that ruling, you can turn around and file a petition for writ of certiorari with the Mississippi Supreme Court. And if they say, yeah, we still don't want to hear your case, well, you're stuck with the ruling from the Court of Appeals. And if they do hear your case, wonderful. And under the most technical circumstances, if you're talking about U.S. constitutional law that's been violated or something along those lines, you may have the right to appeal on up to the Fifth Circuit and subsequently up to the U.S. Supreme Court. Those are not the common cases, but they do come up from time to time.
Any others you want to do?
Um, we can do Miranda warnings and what happens if police didn't read me my rights.
Okay. What happens if the cops don't read my Miranda rights?
So if the police don't read you your Miranda rights, that doesn't mean everything necessarily gets tossed out or your case disappears or anything like that. What happens when they don't read you those rights is anything you say after you were under arrest or reasonably believed you were under arrest can be excluded. So your attorney would file a motion to exclude based on a Miranda violation. That's the remedy. Your case doesn't just get tossed out in its entirety. So if they lock you up, put you in jail, they don't come to you, they don't read you your rights, and they start asking you questions and you don't follow my advice and you talk to them, because remember I've said you exercise your Fifth Amendment right no matter what. If you talk to them at that point and your attorney can file a motion to suppress that evidence. It's not a guaranteed slam dunk. There are some circumstances where maybe you read it, maybe you signed a waiver. There's all kind of things that happen here. And remember, this is your first time doing this. This probably isn't the first time that the police officer has done this. So they may be doing something that seems a little bit slick, or maybe you don't catch, and all that can box you in. But if they don't read you your Miranda rights, a general rule is that anything that you say after the point that you believe that you were under arrest or reasonably would have believed you were under arrest can be excluded. Doesn't necessarily mean that it will be excluded.
Anything else you see there?
What is a Miranda warning?
Oh, what is a Miranda warning?
A Miranda warning, it comes from a case, Miranda, obviously. And what that is you see it on the TV all the time. You have the right to remain silent. Anything you say can and will be used against you in a court of law. If you cannot afford an attorney, one will be appointed for you, yada, yada, yada. Well, the Miranda part of that is you have the right to remain silent. Anything you say can and will be used against you. And it is critical that you exercise your Fifth Amendment right, remain silent. That's what a Miranda warning is. It just tells you, hey, you have the right to remain silent. But as the old Ron White joke is, a lot of folks have the right to remain silent. They just don't have the ability.
Any more?
Let's see. Can I represent myself at 24 and 25? 26?
Hold on, let me find it. 24 and um, can I excuse me, can I represent myself in a criminal case?
You can absolutely represent yourself in a criminal case. I strongly do not advise it. I got a divorce a few years ago, and I had the good sense to hire a lawyer then. And I'd like to think if I had a criminal charge against me, I'd have the good sense to hire a lawyer now on that. It's called pro se. You represent yourself pro se. And I've seen a lot of people do this over the years, and there are times that you just cringe as an attorney when you hear one of their trials or you hear their questioning, and you just want to say, "Man, they don't know to object to certain questions that the prosecution's asking," and it's almost like they walk themselves to the gallows. So I really don't advise people to represent themselves in a criminal case. You are swimming in a competition where you don't know the distances, you don't know the rules, you don't know the time that everybody else normally runs. You don't know so much. It's like I have the right to go change the engine in my truck. I promise you, I'm not going to change the engine in my truck because I don't know the rules and everything. And the best hope I would have is YouTube. You do not want to YouTube how to handle your criminal defense that could lead to either you losing a license or going to prison.
I think we're at about 20, I'm pretty sure, which is kind of a magic number. Um, if you want to add many more, I mean, we can, but
Whatever you want to do or think's best, Steve. Like I said, I saw a couple of them. If you want me to do off the cuff, I can do them. If you
yeah,
want,
sure, sure, sure. Which ones?
we'll do 25. Is it better to go to trial or take a plea deal?
Is it better to go to trial or is a plea deal better?
That completely depends on the facts of the case and the client. If the facts tend to skew in a manner that it's unfavorable, then you need to have a frank conversation with that client and say, look, you got a lot of exposure here. You got a lot of risk. This is what I would recommend. You let me go talk to the prosecutor. But then the question becomes is how risk adverse is that client? You may have a client that says, no, let's roll that dice. I understand that there's a 1 in 6 chance that it's going to come out on my side of things. That's their call to make, not mine. I don't twist folks' arm. I don't plead with them. I don't beg with them. I lay out the facts. I let them make an informed and educated decision. And I take the position that my clients are big boys and girls, and they know what's going on. And sometimes I'll even have them sign something saying that I've walked you through all this. You understand the risks that you are taking, and you want me to move forward and give you the best opportunity at the outcome you seek. And we absolutely will do that. But is it better to take a plea deal or go to trial? It really depends on the case. And if it's a non-adjudication or it's a deal that takes a felony to a misdemeanor, that's hard to tell somebody just to walk away from. And with that being said, I've absolutely told clients, don't do non-adjudication here. Tell them you want a trial. Let's go try this case. This is not a case to go non-adjudicate. But the big advantages to taking any kind of a plea is you have some control over the landing. Um, you still got to get the judge's approval on a criminal case, but at that point what the judge will order if they're going to move forward with the plea deal. But I also tell folks when you take a plea deal, especially if they're holding something over your head, that you're tightrope walking over the Grand Canyon without a net. You misstep, this is the last chance place. There's no what can we do when we come back to court. This is the coming to court for what we can do. So that's something you've got to take into consideration, and you've got to be able to explain to your clients in a way that they understand it so that they can make an informed decision on how to move forward with their case because it's their case.
Did you tell me another one too when we took the trial plea deal?
uh, I thought I did.
I thought you did too. Now I don't remember.
We can do the challenging the prosecutor's evidence, or how does a lawyer prepare for trial. What's the role, how does a criminal, we can do whichever one of those. I don't know how many more you need, Steve.
Probably one more at this point, and we'll be good for quite a while. Uh, so, how does a criminal defense attorney prepare for a trial?
So preparing for a trial, it varies a little bit based on the case type. If it's a felony, it's going to have more work that goes into it. There's more done on the head end. The risks are higher. You're probably dealing with a jury. You want to make sure that your client is fully prepped, and they need to you need to prep them for taking the witness stand in that situation, whether or not they decide to do so, because sometimes it becomes an off the cuff decision there. But we enter our appearance, we file requests for discovery. If we don't get our discovery, we start filing motions, we start issuing subpoenas. All that happens way out. And as all that information comes in, we're starting to put it all together and starting to put a plan in place. From day one, you kind of have an outline of where you want to go, but you need to start putting in your pit stops. And think of a criminal case as driving from New York to Los Angeles. You need to be prepared to stop at a few places. You're going to have to lay over a couple times. Well, you need to know where, what client, what witness comes into play where. You need to put the puzzle together, and just because you know the goals and the destinations doesn't mean you know all the stuff in between, and that's what you're trying to figure out. And we can spend hours, sometimes days, just working on trial questions for our witnesses, getting our trial binders together. Obviously, a misdemeanor case is not the same. It doesn't get the same treatment. And it's not to say it doesn't get treatment that's sufficient. There's just not as much evidence to go over. There's not as much to prepare for. And it becomes much more streamlined, and misdemeanors are just designed to be that way. But we still have a trial binder. For example, if I've got trial coming up on a case, my trial binder is ready 2 weeks out. And in a misdemeanor case, if there's something that we need to go and obtain, if there's something we need to get, 2 weeks is almost an eternity when it comes to a misdemeanor trial to get something. In a felony case, that can be a blink of an eye sometimes. So that's why they receive such different preparation courses, I guess is the way to say, because they truly consume a lot of time. And folks see an attorney in a courtroom and they think, this is where it's happening. This is where the work is. Bullshit is my answer to that. An attorney in a courtroom is like an iceberg. That's the 10% that you get to see. You don't get to see the 90% that's still underwater.
Okay. I think we got it. Anyhow, I'll stick. Oh, here it is. Keep forgetting where everything is because they changed it. Okay. And then